Hi, everyone. My name is Jericho Perez. I'm on the board of the National Hispanic Cannabis Council. I'm a partner here at Vicente Cederberg in our Denver office. And we're here today at our NHCC Legal Committee Roundtable. Today, we're going to talk about opportunities in the cannabis industry, specifically in Florida. So Florida's a very exciting market. We're going to discuss that, and we're also going to talk about the application that's currently open and due on April 28th. We have three wonderful speakers with us today: Jose Hidalgo, NHCC board member Aaron Lopez, and Sally Peebles, another partner at Vicente Cederberg. I'm going to give each of them a chance to introduce themselves. Let's start with Jose. Jose, I'll give you the floor for a quick introduction.
Thank you, Jericho. Jose Hidalgo. I'm glad those of you have an opportunity to join us today. As I was saying earlier before the call, we went to the general group. This is the reason why we started the NHCC, is to create opportunity for Hispanics to participate in the cannabis economy. So, I think that this is the first of hopefully many calls that we will do. The Florida, I'm here in Florida. The Florida market is a unique market that presents a lot of opportunities. So we certainly hope you guys get as much value as you can out of this phone call and out of the Q&A session. We have, probably the most knowledgeable attorney in the space with Sally, and one of the most knowledgeable attorneys as well as, political and goes understanding the landscape of cannabis in the country and also in Florida, who also used to run the public relations for True Leaf in Aaron. So pleasure to be here today. Looking forward to delivering as much value as we can to our audience.
Thank you, Jose. All right, Aaron, your turn.
Aaron Lopez with Political Capital. On the executive committee with Jose for the NHCC. And when Jose did mention that we should do something on Florida, and just particularly on the licensing and joining it, I thought it was an excellent idea. I mean, there's a lot of states right now with licensing opportunities, but Florida, as Jose said, is unique. And it's a question on, what does it take for Florida? It takes a lot. It's different than a lot of other states. And so I'm glad we're having this call. So thank you for the opportunity.
Absolutely. Thanks, Aaron. And last but certainly not least, my partner, Sally Peebles.
Hi, everyone. Sally Peebles with Vicente Cederberg. I have been practicing cannabis law since about 2014 and really focused in Florida. I am licensed in Oregon, Colorado, and Florida, so I'm hitting almost all the time zones and helping clients with their corporate real estate and licensing needs in all three of those states. I'm from Florida and moved back here about 5 years ago to open up the VS law firm, and been watching very carefully the Florida market. And I'm just thrilled to see that the state of Florida will be issuing new licenses. As Jericho said, the submission date is April 28th, so stay tuned.
Thanks, Sally. All right, guys, let's jump right into it. I know we have a lot to discuss. Before we start talking application specifics and what that process looks like, I want to give everyone a 50-foot view of what is happening right now in the industry in Florida. Before we're issuing these new licenses, what does the market look like right now? What's the current state?
Well, right now, we are a medical-only state. Licensees started getting licenses in 2015. Only 5 licenses were issued back then. A lot of people then sued the state, those that were unsuccessful in that application process, and the state issued another 17 licenses via settlement agreement. So that sits us at about 22 licenses now. We have almost 800,000 medical patients in the state of Florida, which is unheard of for medical patient numbers. And every time we hit 100,000 in statute, it says they're going to release 4 more licenses. They have not done that. So everyone has been waiting and watching. There was a Supreme Court case that kind of held things up for a while that deemed the medical marijuana statute unconstitutional. We are past that now. And so we are now forging ahead with a new application process. for an additional 22 licenses. Florida is unique. We've said that a few times on this already. And the reason is because we have required vertical integration here. And not only are operators required to operate everything seed to sale, they have the unlimited capability of opening as many facilities as they want. They can open up 200 dispensaries if they want, as many as they want, which again is very unique to Florida. Most states, one license equals one license equals one facility.
Got it. Thank you for that. And this is a vertically integrated program, right?
Absolutely.
So just one license type?
Yeah, one license type, medical marijuana treatment center, and that is from seed to sale. And these are very valuable licenses because of that unlimited capability to open as many facilities you want. Just the piece of paper we've seen that being flipped for many, many $million, 55 million, 65 million, operating companies on the market for $250 million.
So Sally, I want to piggyback off that a little bit because, we see states like New York, New Jersey, and a lot of these other states, even Texas, and, people are getting a little excited over those, but I still think people are really excited. You said almost 800,000 patients. You would think that we are becoming saturated, with too many almost, but it's not. Florida, is the crown jewel and is still the target for it, for a lot of this. And I think because of what you're saying, because of the integrated, you look at New York, it's one or the other. You either got a grow facility or you get dispensaries now, even with New Jersey and all these other things. But what still makes Florida that hot market for these? I mean, you've got 22 licenses, you've got 537 dispensaries open across the state. Why still Florida though?
We're such a large city. Go ahead.
I was going to ask, just to, again, piggyback off of what Erin just said, it's a medical market, right? So it's vertically integrated. What is the driver for the opportunity here? What about qualifying conditions? They're not super limited in Florida, right? So is that why the patient count's so high?
They're not limited, and there is a clause that'll give some discretion to the doctors. That's been heavily scrutinized, whether or not there is such wide discretion. But it seems that doctors, and in my opinion, thankfully, are using that discretion and making sure whoever needs this medicine is, in fact, being able to be prescribed it.
Yeah, that's so important for patient access and, leads to patient demand. So let's get into the exciting stuff here. There is an application open right now. There's a licensing opportunity. It's been years since this has been available in Florida. Could you guys talk a little bit about how many licenses they're giving? I know we already talked about the due date, but a little bit more about what that looks like, who's grading these applications, what's going on with this application process?
You want me to take that one, guys?
Go for it, Sally. Yeah.
So we just had an application process last spring, and that was for one candidate who qualified under a 1990s anti-discrimination case. And they used that same application, and they're reintroducing it for a general applicant for 22 new licenses. To qualify, you have to have many requirements, but the main threshold ones are going to be, you need to have a medical director on staff. You need to have Florida Department of Agriculture nursery certificate, and what else? Nursery certificate, medical license.
But it's that, you bring it. Okay, so our target audience for this is actually members of the NHCC and trying to come into and trying to understand this. And so I'm glad you brought up some of these and looking through these, and I'm wondering if these still apply. Do you still have to have been registered to conduct business for the last 5 years in the state? Is that still one of the requirements?
That's the third one. Thanks for that. It used to be 30 years, which was an interesting requirement, and really made it so that many minorities were just carved out and completely excluded from that first round that happened in 2015. Now you do have to have an entity that's been registered to do business in the state of Florida for 5 years. And that FDAC certificate just has to exist. No longer has to be a 30-year nursery.
So if I'm out of the state, and I'm looking at Florida as a potential license, how do I overcome that?
You can purchase a shell entity. There are some floating around on the on the well, if you just Google shell entity, I don't really know names of companies. It's a little sketchy to do that, but you certainly can do that. You just need to do very strong due diligence. Also, ask your friends and family members. I find that most clients have really had success just saying, hey, do you have an entity that held a piece of property for a few years sitting around? And you can use that entity to apply. You just need to, make some amendments on the SOS and create a new operating agreement with your team.
So it doesn't necessarily have to be. Go ahead. I'm sorry, Jack.
Oh, I'm so sorry, Aaron. Forgive me for interrupting you. I think we were probably going to ask a similar question. Does that business have to have been operating for 5 years? Does it have to have been related to cannabis? Can it just have been sitting there for 5 years?
Could have just been sitting there for 5 years, as long as it's had a continuous registration with the Florida Secretary of State's office. Very quick search on the Florida SOS site will be able to confirm that. But again, you do need to do your due diligence. You most likely don't want to use something that's been used in heavy litigation or has a bunch of loans on it. You don't want to step into a mess, right? But you can just hire an attorney to do that due diligence for you, or do it yourself, and you would be able to use that company to apply.
Interesting. Okay.
Sally,
Go ahead, guys.
Going into these three key initial, say, requirements, for consideration for application, can you elaborate a little bit for the group about the DAX license? So they get their 5. They have an LLC, call it, a business that's been established for 5 years, whether they friends and family own one, whether they acquire another one. That's a requirement. And then you're talking about the DAX. No longer you need the 30-year nursery requirement. How do they go about doing that?
So the FDAX just stands for Florida Department of Agriculture Nurseryman Certificate. They just call it the FDAX certificate in the application. That is a certificate issued by the Department of Ag for a piece of land that you presumably will be cultivating on. So if you have a piece of property, whether own or lease, or you have a friend that has a piece of property, you can call the FDAX or go to their website. It's very user-friendly. You put the address into their map and you call the plant inspector that's matched, or just call FDAX or call me and I can help you figure that out. It is not a very complicated process. And if there's no plants on the property at the time, it costs about $35. So this isn't a heavy lift. I would say get going on that sooner rather than later, because there's so many people asking FDAX for it right now, depending on what part of the state you're in. It could be up to 2 to 3 weeks wait. Most recently, I've had a client get them in about a 2-week turnaround time.
Thank you.
Got it. Quick question for you guys. So, a lot of the states we've historically talked about at this roundtable, New Jersey, New York, others, there's a social equity component, right? There's specific opportunity for social equity applicants. And I'm sure people watching are wondering if there's something like that. Is there an opportunity there for social equity applicants in Florida, or is that something that doesn't exist here?
So I think Sally was mentioning it a little bit for the last year, and it's fascinating. As somebody who's, I think, dedicated to Florida, Sally, I think I would like to understand the Pickford case and a little bit more on those social equity licenses as well. And I mean, that's a specific target. It has nothing to do with these licenses. And in other words, they're not, getting out or taking a portion of these. Like other states, we see 25% of the licenses have to go to a minority, or, and they list what kind of a minority qualifies. But this is a whole different process here.
Yeah, so as Jericho said, in most states, there is a carve out or is certain number allocated for social equity applicants or someone who qualifies as a certain minority. Sometimes women are listed in that list as well. In Florida, they attack the social equity or address the social equity issue in 2 different ways. First of all, the statute did require 1 license. Yes, unfortunately, just 1 license to a claimant in the Pickford lawsuit. This was an anti-discrimination lawsuit where African-American farmers were denied funding back in the late 80s. And I think there was a class action suit that was resolved in the early 90s. And if you were named as a class action member in that lawsuit, meaning you were one of those who was denied federal funding, you could apply. Now, keep in mind, this was a case that was quite some time ago. So most of those applicants, most of those claim members are deceased. There were just a handful left, and I believe only 11 class action members submitted applications last March for that. And they announced the winner last fall, and there has been very expected and very ongoing litigation surrounding that license award that we're calling the Pigford license. Secondly, as part of the application, we had this in 2015, and we saw it in the 2018 variation of the application that never moved forward. And again, we're seeing it with this application. They have a diversity section. Interestingly, one of the only differences between the Pigford application and the general application we're seeing now is that they give that diversity section less weight. You get less points for qualifying under it. But as part of that, you will have a narrative of how you are going to support to diversity. You're going to talk about what vendors you use, and how you will maintain those relationships and being able to support your relationships with minorities, whether through employment or using them as consultants and such. So not a lot of emphasis in Florida on that. I think maybe in some ways they were like, we gave the Pigford license out, we checked that box, we're done. But I do think that diversity, the diversity section is a place where minorities can hit a home run. So a good place to focus your efforts.
So I want to talk, you're talking about narratives, right? And you're talking about these weighted sections. So can you guys provide some commentary on the nature of this application? We see applications where it's a threshold meet the requirements, right? You submit a form, you meet the legal requirements, and you get a license. You guys have said that there's 22 licenses available here, right? So it's not unlimited licenses. How do you get one of those licenses? How are they going to decide? I'm hearing the words narratives and weighted. So talk a little bit about that.
Let me just say one thing before we get into this that I wanted to touch on what Sally was saying, because this kind of is going to lead into the conversation about the application. For something as contested as these applications are expected to be, you cannot take for granted any point that you would score in this application. So this, although not as meaningful in terms of what the Pigford license were, because there was a particular class category that were part of this lawsuit, every point is going to count in this application. So, and also another thing with Florida, we are a very diverse state. So, a lot of this plays into the fact that, having the National Hispanic Cannabis Council have a chapter in Florida, I think it's possible, but I think is a bigger focus to be like where we are in the tri-states into some other areas, although obviously, we are here, we live here, Sally lives here, I live here. So, I think that that's something to keep in consideration. But, every piece, and I'm going to defer to Sally and Aaron to speak about this, none of these, and I know generally speaking, people are just thinking that they need to meet some criteria. This is far from meeting a criteria in Florida. So, and particularly when you're talking, like Sally says, 10 years ago, when these initial licenses were granted in Florida, these first initial 5 licenses, only 28 applicants applied in Florida in 2014. Okay. Now you fast forward to Pennsylvania in 2017 with that, the new licenses were going to be granted. 667 applicants applied for those original licenses in Pennsylvania. I can only imagine the numbers that we're talking about. So a very different time for an application, a very different time for the industry, a very different time for technology in the industry, a very different, there's a lot of trials and errors that these various state agencies have gone through. They have regulated these licenses for now 10 years. So the knowledge that an OMMU has today from when they were regulated, the original 5 licenses has grown tremendously. So you need to expect the sophistication in Florida is going to be much greater.
Right. And I think, Jose, you're being a little bit modest. You certainly are an expert in this. You've been through this process in Florida before. It was a little different years ago, but I do want to give you the opportunity here in a little bit after we talk about some application details to talk about, red flags, things that people should watch out for, be aware of, what they can do to position themselves best to win. But before we get into that, I do want to give Aaron and Sally the opportunity to talk about exactly what you're saying, how competitive this application is. It's not meet the requirements. Is that right, guys?
Well, so I've got a lot of clients that have been looking at Florida, and they're wondering, they're actually a little scared of even applying in Florida, thinking that, I'm not a big MSO, I'm not this, because they understand, to Jose's point, that I mean, this is a very sophisticated market. The regulators are more sophisticated. The market is more sophisticated. The patients, are more sophisticated. And so when these guys look at these licenses and these applications, it's not like when North Carolina or South Carolina are going to open up. This is going to be the first time that they look at these kind of things and trying to figure out, what makes a good, applicant. They're going to know. They're going to be able to see this. And so do you have to be a multi-state operator, with already, 400 dispensaries under your belt? I don't think so. But you do have to come into this with your eyes wide open and understand, who you're going to meet. And to Sally's point, there's going to be different parts scored on this application that you need to address these. You need to go through it, understand what they are. I mean, the application is out there. It's already up. And while you have a small window and it's not until April, if you're not already looking at that application, you're late. This is something that you should have and you should have access to, already. So paying a close attention to it and going through it step by step, whether you're a small operator or a large operator, I think making sure that you turn in a quality application, you'll have a shot.
And just to your point, Jericho, it's good to understand that in a lot of states, it is very black and white with, for example, in Colorado, if you have a clean background and you have a compliant location and you pay the very small, maybe $3,000 fee, you can get a license. There's no cap at the state level. What Florida and some of these newer states that are a little more hesitant about regulating marijuana, they think it's a great idea to limit the number of licenses at the state level. We try to remind them that whenever a state does that, it immediately means lawsuits, but they don't listen, alas. So they do limit it. And that means it's a competition. That means you're going to get points, because if there's only 22 spots and you've got maybe 500 applications, they've got to have a way of sorting them out and making sure who are the winners. So you do have to draft narratives, talk about how you're going to meet certain criteria. A lot of clients, a lot of applicants will partner with teams that may be able to show that relative experience on the application. You may want to talk to investors to make sure that your audited financials, which is a required piece of this, can show that you do have money in the bank. Because one of the primary concerns of the regulators is, if they do indeed give you a license, do you have the capital? Do you have the ability to execute on your business plan and operate this? And like I said, these licenses are unique. You're not asked to open one dispensary or just one cultivation. You have to show that you have enough money to operate everything seed to sale within a certain time frame. So I know it sounds daunting, but there's a lot of ways to thread this needle. For example, you could put in your business plan that you're going to start small. So what does that mean? You need less money in the bank to start. Just be very thoughtful in your responses and make sure everything ties together, and plan to operate these. I think those that really have the intent to operate these licenses and are not looking for a quick exit, a quick flip, I think that will be reflected in your application and your intent, and you'll have more likelihood of getting a license.
One thing I want to add is this. You're talking about, Aaron, multi-state operators, the unique of the application. First of all, they're not going to be looking at who the company is or if they are in other states. They're only going to be looking at the basis of the application, that the principals have passed their background checks, that to Sally's points, that the business plan is sound. There is a word limit, although of course you can put your font to be one, to be obnoxious, but there is a page limit for these applications. Your financial ability to carry the operation, to Sally's point, is paramount. But my early observations about this new round of applicants is going to be like, just money for the sake of money is not going to get it done. These states have become very sophisticated, so just having somebody that has very deep pockets is certainly going to help, but it's not going to guarantee that you're going to get one of these licenses. Also, the narrative is very important, to Sally's point. How you're going to lay your business out. It has to make sense. Your audited financials are going to have to back your ability to have enough capital to run this business for 2 years. You're going to have to get your approval for cultivation within 60 days of that license being granted, which means you're going to have to be ready, even though for those folks that may think that, flipping a license may be a good idea. And I'm not saying that it may or may not be, but there's going to be probably more licenses available for sale in the state of Florida than they have ever been before. So those that are applying and are very serious about operating that license most likely won't get that license because the state will be able to see through it. So these are some of those things to keep in mind.
Thanks, Jose. Yeah, so I had our national licensing department with Brian Vicente, and we kind of have a saying here with the Holy Trinity when you're doing these applications. It's money, property, and team. And I've heard you guys talk about this financial piece quite a bit. You mentioned audited financials, Jose. So it's not necessarily just a narrative saying, here's how much money I have, and here's how much funding I might get in the next 3 years. What do audited financials mean for those who may not be familiar?
So they are going to do like a CPA audit, which is a snapshot of exactly how much money you do have in a bank, how much debt you have. It's a snapshot of your assets and your liabilities based on your financial statements. It kind of goes back to our original discussion on the shell entity. If you are going to go on that route, you are going to need to put money in a bank in the name of that entity as soon as possible. It goes through your fiscal year, and actually fiscal year can be defined as the company defines it. So it's whatever the end of their accounting year is. It's not necessarily December 31st. I've had a lot of people say, but it's over. It's not over. You just would define your fiscal year as what you need it to be. But the financial audit in the past has acted as the tiebreaker. So it is important that, as I said, it shows that you have enough money to fund the business plan that you're discussing. So to Jose's point, you don't need $50 million if your business plan doesn't reflect that you need $50 million. But if you're saying you're going to come out of the bat with 50 dispensaries and 200,000 square foot cultivations, you better have the money dedicated and reflected in your financial audit to be able to execute that plan.
Also, thank you, Sally. What makes this also unique is the fact that it's not a one size fits all. It's not like everybody needs to have a particular cultivation and needs to have a particular extraction, So, your narrative is particular to your business, and you're going to be, and this is why it's a bit subjective, because your business is not going to be measured, your application is not going to be measured in the same basis to the other applications, because one may be doing hydroponics and the other one may be doing, an entirely different type. Some might be doing greenhouses, some may be doing indoors. So, there's going to be your own business, and that's why in my personal opinion, I think it'll be very hard for people that are not operating in the industry today to fake an application. I think it'll be very hard to do that. I'm not saying it's impossible, but I think it'll be hard, or at least not having an experienced team that has done that coming in. The other requirement that you have there, besides those three first requirements that we're talking about, was the performance bond. And you still have the same requirement of a $5 million performance bond, right, Sally? And then that goes down, I think, then face value once you reach 1,000 patients, like before, I believe.
Yes, sir.
Yeah, that's right. So we're talking about these requirements. In a lot of states, we see that property is required, right? And that can be a huge expense. We're talking about financials. In some states, property is not required, like Illinois. You didn't have to actually submit a specific address for dispensary property. So what are they looking for, if anything, as far as property goes on this Florida application, especially when we're talking about the ability to have unlimited facilities?
So for the cultivation, we already discussed the FDAC certificate. So that's really the only 100% required property. You do have to show that you have some land where you can cultivate, that FDAC has given you a permit to do so on. For the dispensary and the processing, you are supposed to, well, let's take a step back. Everything's graded on a sliding scale, right? So The most points you could probably get for there is when you're discussing the properties you're going to use, saying that you have properties nailed down and purchased. Then maybe a step down below that is an LOI on a property. Maybe a step down below that is saying, well, these are where we're kind of looking, so you're going to get the amount of points as to the surety of your ability to exercise and your ability to have possession of that property. There's an entire section under dispensing and processing and cultivation where you discuss your ability to execute your facility plan, meaning how sure are you that when you say you're going to open a dispensary in Coral Gables, you can do so? Is it allowed there? Do you have a property? What's your type of possession? Do you already have something executed? How many contingencies are in that document? Or are you just saying this would be great if I could open 5? You might get less points for that. But again, it's not required to have possession. But I would say that the winning applications, most likely, because as Jose said, every point will count. You do want to have, most likely the winning applications will have at least an LOI on a dispensary.
And what about, how does that work with the localities? If you've done this before, that it can take months and months to get local approval. Is local approval required here? Should applicants be conducting local outreach now? Can you provide some commentary on that?
Before we get there, let me back up a little bit here just to help those that are, because let me also encourage you all that are on the phone right now. There is time for you to submit an application in the state of Florida. 100% there is. Don't be discouraged by what we're discussing. But I will tell you one thing that I will discourage you from doing if you want to apply and you just started thinking about it today. If you plan to go into a commercial type of real estate, you are not going to be able to get cultivation and processing done on time on the property. And that's probably going to be a hard hurdle for you to overcome. So staying in an agricultural property is going to be key, not just for the FDAX certificate, which, as Sally said, you should fairly easily be able to do it, but having an agricultural property in the state of Florida is going to exempt you from the permits of building your manufacturing facility. Now, you're going to have to be looking at what type of these properties you're allowed to, because there's some restrictions, as Jericho was saying, depending on the municipality. But to Sally's point, everything starts with your ability to get that that approval to cultivate from the state. You should have within that same property some manufacturing capabilities, and then from that point on, you're talking about the dispensaries, and that's, imagine there's 500 plus dispensaries in the state of Florida. There's going to be thousands of people, because imagine if there's going to be, let's say, 1,000 applicants. Those 1,000 applicants are going to have a handful of realtors each. So plus some of them are already going to be in real estate. So you can pretty much rest assured that there will be a lot of people looking at the same properties. And so is going to, some of those prices may be astronomical, as we've seen in Florida, Sally, right? And so, Aaron, I think that although it would be a nice thing to have an LOI, I would think it would be very difficult for somebody that's planning to apply just now, that they're just going to come up, unless they own the real estate, coming with 5 dispensaries in areas that they can open,
And I think that you'll be able to look at, to your point, Jose, Florida is a lot more sophisticated. There will be those real estate agents that have gone through this, have been through this, with already 22 licenses, and some of these guys having massive grows already. They're going to be, some of these local experts are going to be pretty aware of what cities are going to be more friendly than others. And I would try to look at those, making sure that you're up with the current state and laws, and, what's going to be imposed on these different areas. But looking at some of the zoning, and I think to Jericho's point, looking at some of the zoning, looking at some where these other people are already located, they're available, but you're going to have to look. You're going to have to find them.
Thanks for that, Aaron. Sally, go. It looks like you're about to say something. Go ahead.
I was just going to say, it's important to understand that while cities can ban dispensaries within their local jurisdiction, they can't really ban cultivation or processing. So there's going to be a lot more opportunity for that. There are cities out there who have banned dispensaries. However, if a city or county does decide that they will allow dispensaries within their jurisdiction, they are not allowed to discriminate terribly against them and zone them so they're out of existence. They have to be allowed wherever a pharmacy is allowed. So while you're out there looking, check your local zoning. Make sure, number one, that it's allowed in that local jurisdiction. And if it is, check to see where pharmacies are allowed, what zones those are in. And that's where you'll find your ability to place a medical marijuana dispensary. And then call the planning and zoning, get a letter if you can that says they would allow it. Because sometimes these local jurisdictions have gone rogue. And even though they're only allowed to place it where pharmacies are zoned, they've decided to do their own zoning. And even though that's not allowed by state law, they don't care. And so it's a good idea just to double check with them.
Thanks, Sally. So to sum that up, it sounds like, and correct me if I'm wrong, you do not have to have local approval in hand, right? You don't have to have zoning approved in an actual document. You don't have to have your CO, your certificate of occupancy, or something like that, right?
No local license, no local requirements, but you will want to discuss how your proposed facilities are compliant. That will go under the ability to secure.
Got it. And what about things like floor plans and these detailed things that can take time? Is that something that's required an applicant should be considering now?
You can attach them as exhibits if you would like, and those will not count against your page limitations. I would say the stronger applicants will have that. So that it's not too daunting of a task. If you want to just have a proposed floor plan, it doesn't necessarily have to be to the building that you're actually looking at. That'd be great if you could, but if you just want to have a rough idea of what it would look like, that would be a good idea to attach.
Got it. Thanks for that. So a little bit more about the detail of the application. Both Jose and you have said there are page limitations here, which is great because sometimes these things can turn out to be thousands of pages, right? People are just submitting massive stacks. So it sounds like there's page limits here. What are the type of things, especially for applicants who have never operated in the industry, that they're going to have to submit? Are we talking SOPs and operating manuals? What do the narrative components for operations look like for this application?
Generally, you want to make sure that you are referencing the actual law throughout, and you're really just answering the question as it is asked in such a manner to make sure you're hitting and talking about how you're going to be compliant with every law that would be applicable in each section.
The other stuff, and I think Jericho, I think you part of the difficult things for somebody that's coming into the state. I cannot highlight enough what Sally just said, because when you're looking about legalese, it's not really compatible with running the cannabis business, if you really think about it, because you really are speaking to the law and satisfying the regulators with the law, and then you have to have a piece that is operational. But you're going to have your team. I mean, the guys that are going to be managers and the guys that are going to be guys and ladies that are going to be owners of this business are going to have to pass a background check, and they're going to have to be disclosed to the state. So at a minimum, you're going to have your management team and of course your ownership team. I'm not saying you got to have every single person, but medical directors, security directors, your head of cultivation, your head of labs, your manager, president of the company or whatever, plus any of these any of your capital partners they're going to have to pass a background check. So that's a requirement that you need to have, even though you are not required to say exactly where you're going to have the dispensaries. You don't even really need to have a floor plan. You don't even need to have an LOI. There are certain things like the property with the FDAC certificate, the bond, the audited financials, and disclosing the team that passes a background check. Those are just bare minimum requirements in order for you to get in the game.
Yeah, I think that's an important point, Jose, bare minimum requirements. And I just want to emphasize again that this is a competitive application graded on a scale. So it's not meet requirements. You have to meet the requirements to even be considered, right? And then they're looking at these narratives, grading them, and ranking each application. Is that right?
Absolutely. The other stuff is this. I mean, although you are allowed to do amendments, addendums, and although you are allowed to use hyperlinks, don't be annoying with them because you will annoy the scorers. So you also have to make sure that you use this tool wisely for those areas that you really want to. Like Sally says, I think that having a general understanding, which is, has become, I know we have evolved in Florida, but I know having an understanding of how you plan to lay these dispensaries out is probably not a bad idea, so they know kind of the type of stuff they're going to be regulating, because to Sally's point, they're looking at the letter of the law of what is required for these dispensaries, and they're looking at, okay, have you really thought about, the layout and the considerations that's going to take for that? The same is going to happen for the cultivation and manufacturing and so on.
Right.
I got a question real quick for Sally and Jose. Something different that I found in this application that I have not seen in any other is a citrus preference portion. And if I'm looking at trying to, I've already, I already had a conversation with this with someone else. If I'm looking to get every little point, and they're going to take an opportunity to round up a few points for me with the citrus preference, I can see where a bunch of people are going to try to go buy a citrus plant or something like that and say, I'm going to try to rehab it. I mean, this is money. This is things that people are going to try to involve. I mean, maybe if you guys can explain to us a little bit of, if you understand what the citrus preference is, and good idea, bad idea to try to go after points of that nature.
So Florida citrus industry was cherished. And unfortunately, it for several different reasons is heading downwards, and it has been. So I think giving applicants who have partnered or have bought a citrus facility is kind of a nod to that industry to say, we see you and we're here to help. It's trying to breathe new life into these facilities that are found all over South Florida that were used for citrus processing. And the key, which you've already touched on, but the key here is that you can't just partner with them. The facility itself, the deed, has to be in the name of the applicant. So that is a pretty high threshold to meet. You can't just partner or say you're going to. You actually have to submit the deed with the applicant's name. So that might be an expensive purchase of a facility, or maybe it's part of a swap in the partnership deal. And the way that the mechanism that's going to work is a little confusing, but I'll try to explain it. So they're going to rank, let's say 1 through 10, there's 10 applications, and they're going to rank everybody. If the top 2 applicants that also qualified under the citrus preference will get an extra set of points, and let's say 35 points. And those 35 points may or may not, hit them into the winning circle. So let's say they were in our specific example, they were number 23 and 24 had citrus preference, and everyone ranked, and I was number 23. I didn't make the cut, but I had that citrus points, and I was those top 2, and I was the number 1. I would get those extra points, which may bump me up to getting a license in the application. Should you go for it? I'm telling people that don't feel bad if you do not qualify for this. It's not enough points to freak out about. If you have access to one, heck yeah, go for it. Every point matters, but I certainly wouldn't shy away from applying if you don't have a citrus facility. So
you're saying it's the top 2 scores of those that are applying with the citrus, component to it. So not just everybody that applies for it that with the citrus is going to get bumped. It's only the top 2. So you have to be really great in every other aspect, and be the top 2, and then those 35 points can knock you into the winnership. Right. Thank you.
Thanks, guys. So we're getting close on time here, and I do want to give a couple minutes for people to ask questions in case they have them. So I want to give you each an opportunity to provide some closing thoughts here. What are the most important things that people need to be thinking about right now if they're wanting to apply? Anything else you want to add before we jump into questions and close out? Aaron, I'll let you go first. You're on the screen.
Awesome. Well, I even wrote mine down just because I thought if there were key things that I was going to tell people, and I kind of already kind of hinted at them. So first off, know the current laws and regulations. Make sure that you understand what they are. Know which counties and local governments are medical marijuana friendly to avoid some of the needless legal battles associated with zoning, permitting, and bans. So to Sally's point, if you can get a letter, you just say, yeah, they would accept this type of a business there. I think that's brilliant. Anticipate where you will get your initial funding, the startup costs, the application process, and the early years will be the most expensive. And this is an expensive application. I mean, we went from $60,000 before to I think it's almost 150,000, 146,000 for this application. That's the application cost. It's not the 5,000 in some states and or whatever this. I mean, it is an expensive barrier that's going to hit a lot of people. And be sure to have access to ethical lawyers specialized in state cannabis laws. Obviously, if you get people like Sally, there who know it, understand it, you're going to go a lot further.
Thanks for that, Sally.
Yeah, I'll add, I think that this industry is ripe for some color. It'd be great to see some more diverse people holding these licenses. It would be great to see more mom and pops holding these licenses, though I celebrate anyone. These MSOs, sometimes people are like, oh, corporate marijuana. Well, they were the ones who really put their name in the hat and took that risk, and great. I'm glad they're successful, but I'd love to see some new players. And then the second thing is everyone who's listening, Google the words 280E and make sure you're very familiar with what that is, and make sure that all of your early steps doing corporate structuring and your team members and your financing, you find out the consequences of that tax code and make sure you're structuring so that it doesn't have a lot of effect on you. It's the bane of the industry, and no webinar on cannabis should go without mentioning it.
Definitely. All right, Jose.
I love to open it to questions. I think that to Sally's point, I am certain that there will be a lot of new smaller companies entering in Florida that put a quality application. I'm excited to see that. I also, we have a real momentum behind the adult use for Florida. It perhaps can become a constitutional amendment. It looks like it will be a constitutional amendment by the year 2024, which means that these 44 licenses will be grandfathered into what it would become the most coveted adult use market in the country. So, I think it gives a head start for those that are able to get in the game now. So exciting times. Look forward to seeing what our audience have to ask, and hopefully they got as much value as we wanted them to get out of the call today.
Thanks, everyone. Okay, we have a couple minutes left. If anybody has questions, please do go ahead and type them into the chat. This is your opportunity. Obviously, you can follow up with us as well. We're always here to answer questions. But please, if you have any questions, now is the time to put them into the chat. I haven't seen any come through yet.
Sally, while we're waiting, Jericho, I would like to, since I've got an opportunity to ask you a question, so I can understand it better.
You can call me anytime, too.
I will
do that.
But this idea to be a patient in the state, and this might help people deciding whether or not it's not just a permanent resident there, but you get seasonal residents, if I'm not mistaken, are also eligible patients. So when we look at the 22 million people that are in the state, it's not just those that are in the state, but snowbirds as well.
Absolutely. And one of the first things we do when we analyze as a new state's regulatory structure is, do they allow for reciprocity? Meaning, will a patient from another state be able to bring their patient card from that state into Florida and buy marijuana using that card? That will really tell us what the market will look like in that state. So Florida doesn't have pure reciprocity, but it does have the seasonal resident that you touch on. I think that's because we have so many snowbirds, and if they show that they live here for a certain portion of the year, I think it's 90 days, and they have some sort of possession documents show that they're here in the state for that time period, then they qualify as a patient and can get their card and purchase here.
That's huge. We don't see that in a lot of other states, so that's great.
Right. Okay, well, you guys just have been so informative that we don't have any questions. Again, if anybody watching does have questions, do follow up. Don't hesitate to reach out. And we're here as a resource. I think that's it, guys, unless you have anything else to add. It's been a pleasure having you. We appreciate all three of you, and have a great afternoon.
Thank you, Jericho. Thank you, guys.
All right, thanks so much for having me.
Bye.
Okay, rest of your week, guys. Bye.